Link decides she wants to dismiss that case. I don't know. I don't want you to say anything right now without talking to your lawyer. Would you talk to your lawyer first to make sure that we think that you're guilty of that offense? Because if I misunderstood what he said to me,
Welcome to BenchScope USA.
pled guilty. I'm not going to take it under 7411. He's got another case where he had one. I'm prohibited from doing that. He's got another drug conviction. I don't know if we covered that, but I'm not going to take that under 7411. 2014. I didn't say pills. I don't know what it was. Pills marijuana. I can't do it. So if you want to go talk to the prosecutor again, you can. If you want to tell me, Judge, we'll just accept that as a plea as charged, that's fine. I will still honor the other charge, the resist and obstruct under 771.1 that he pled to. And that's back on. What day did I take that plea? What day did I take that plea? I wasn't very good at noting this. Heather, it looks like on June 17th. So I took that
Yes,
plea
Judge, it was.
June 17th. And you can just tell me what he wants to do.
He wants to move forward with the sentencing.
So you acknowledge and understand that this conviction for possession of a controlled substance will go on your record, that I'm not going to take it under section 771, section 7411. The conviction will immediately enter. It will be on your record. It's not going under that statute, and I will sentence you on that case. Do you agree to that? You acknowledge I need not take a plea again, counsel?
Yes, Judge.
All right, I'm just give me a second to make a note. Case not taken per 7411. Please make a note of that, Heather, because defendant had prior drug charge in 2014, prior drug conviction in 2014. So I'm just going to go ahead and sentence you anew on that. And with that, counsel, we have plea as charged, possession of a controlled substance. We have a plea to resist, hinder, and obstruct an officer. And that's going to be taken under section 771.1. And there was an acquired fight charge that the prosecutor agreed to dismiss files C. So I'm only going to deal with files A and D. Have you had a chance to review the report with them? Are there any material additions, corrections, or deletions?
We have used the article addition, deletion, or correction.
Anything that you would like to say on this behalf?
If you're on, I mean, the court says he is employed, he has a couple of children. I would ask for the court, if the court is going to order days on that court work program, the court will take into consideration that Mr. Johnson does work full time. He does like to spend time with kids on weekends, so I would just ask if the court will take that into consideration. Other than that, you have to the court will adopt probation and organization.
Anything that you would like to say?
Apologize for John to the court. Given that the one you know before you come to talk to the actually fairly you probably not work time. Don't do it because you also we have is that one not near one far. Feels that I did have an authority and some opposition that I'm not functioning. So it's like that. And I think with the state, the case about how stuff, that's one picture.
Well, that's nice to know, but why would you have possession of something if you don't use it? Why would you have possession of opiates that were not prescribed to you that you reportedly obtained from another individual? Why would somebody acquire something? You have to take your head off, please, sir. Why would somebody acquire something and have it in their possession? Should not use it.
Some of the other day was person that was fixing on the car that wasn't buying. He probably didn't enjoy it. He thought, oh, no, statement. And he probably got bought. I did put them on pocket. Price who prescribed me a prescription for. One time I did have an emergency off base. He wouldn't prescribe.
So you were just going to self-diagnose?
Yeah, they only gave some antibiotic drugs. So I was about training. Maybe I see, so I didn't even know exactly when they were, so I didn't actually teach it on like what you have to that is a type of medication.
So you drive out to Ann Arbor every day?
Just for 9 times, I work. Yeah, I've been here about 12, 10, 3 years. Drive about 4 years. Sure.
And are you primarily, you still have, but you still reside, correct me if I'm wrong, with the mother of your children. Oh, so she worked,
She was working for,
I didn't ask you.
oh, right now she's not working. We have a 1 year old, full time, like, so she's not working.
You gonna straighten out your life here?
So, yeah, we do a shop on Tuesdays,
But then you tried to evade the police, right?
no, actually,
You didn't try to evade the police. You told me at the time of the trial. Hang on. I asked you what the basis for the resist and obstruct was. You said you didn't stop when you knew they were trying to pull you over. Do you want me to go listen to the tape?
no, you know that.
Well, is that what happened or is that not what happened? I'm not trying to trick you. I just don't want you to come up here sounding like a choir boy when you tried to evade the police. They could have charged you and should have charged you with playing a loose. You got it? Can we agree to that? I don't want him just to tell me he agrees if he doesn't agree. I'm not trying to trick anybody here. That's not what my purpose is. I just want to have a discussion with you and try to figure out why I think that you're going to do better. And I can't say I see a lot of reasons on that right now. All right, counsel, what else? Anything else that you want to say? I mean, if I'm missing something, feel free to tell me, Judge. I don't think you're looking at this right.
So you're gonna, during the night, it was dark outside. Mr. Johnson did see police. I don't think it was an intentional invasion at first. It was he thought they were behind somebody else. It was dark. And you got all these police lights behind you. So once he realized it, which was a mile or so later, he did pull over. But it wasn't an initial, I'm just not saying police.
Well, at some point he had that mindset. Is that true or false? If it's false, then I shouldn't have never have taken the plea. Right?
It was a situation again, Judge, it was done. You got all these.
I know, but I'm just asking you, if he wants to withdraw his plea because he doesn't think he did anything wrong, I thought at the time he told me he drove when the police were following him. I'm not trying to listen. I'll let you withdraw your plea right. If I made a mistake by accepting a plea that I shouldn't have accepted, I'm going to let you withdraw your plea.
Yeah.
I thought you told me at the time of the plea because I couldn't understand for the resist and obstruct because you didn't provide me any beginning. Was that yes, you knew the police were coming after you and you continued to drive. Did you tell me that or not? I'm just asking you, did you tell me that or not? I don't, I know how I do things and I know I don't take pleas when there's not a factual basis. I know I don't do that. If I do, I've made a mistake. And if I've made a mistake, I'm going to rectify that mistake and allow you to withdraw your plea right now. And I'm serious about that. In fact, I'll let you go talk to him about that. I'm glad to do that because I don't want to take a plea from anybody, anything that's a criminal charge of any kind. If they didn't commit the act, and I thought that's what he told me. If I misunderstood, it's my fault. I'll accept responsibility. I won't withdraw his plea. We can go back to square one, go back and negotiate with the prosecutor. But I thought I heard him say that. If he didn't say that, then that's my fault.
Well, then I think he said when he knew they were behind him and he should have pulled over. I guess either just to be sure that they were behind us.
I don't want you to say anything right now without talking to your lawyer. Would you talk to your lawyer first to make sure that you're guilty of that offense? If I misunderstood what he said to me, I do not want to go forward with the sentencing on the hour. Right? And in fact, if he's not guilty of that, the prosecutor can reevaluate, decide she wants to dismiss it. So I don't know. I'm not gonna take pleas. And then take somebody from a sentence and tell me something different than what I thought they said. So if he said something that I misunderstood, my fault, I take responsibility, and you guys can go back and talk to the prosecutor. But I think you should talk to your lawyer before you say another thing, okay? And again, so you got two charges. If he doesn't feel like he's guilty of the RNO, I don't know. Okay? Thanks. Thanks. Raymond Lawrence, winner with second, 261-50596.
Good morning, our Bianca Taylor, 8237 on behalf of Mr. Wilson, say
Good morning, sir. This charge here is a malicious destruction of property. If requesting a bench trial, is that right?
correction.
You have the constitutional right to a jury trial, sir. Jury trials being paneled, all six would have to agree that you are guilty beyond a reasonable doubt. In order for you, by waiving your right to a jury trial, I will be the one to solely decide your guilt or innocence. Do you understand? You wish to waive your right to a jury trial. Anybody in the world force you to do that?
No.
I'll accept the waiver. We'll set it for bench. What do you have for me, Heather?
Judge, do you want to do this bench trial on one of our Wednesdays or one of our Thursday Brownstown days? Or do we need to do it when Mr. Teo's here?
Mr. Teal's here on Thursdays?
I don't know if she has any Thursdays with us.
No, I don't. Actually, Wednesdays, no, Thursdays included.
Can I get you to come in on a Thursday, or do you not have?
It depends on the day.
How do I look on the 16th, Heather?
I mean, we
Who's that? How about on the 30th?
we don't have Brownstown on the 30th.
I don't have Brownstown on the 30th?
No, we have them on the 16th.
Thought I had them every
Or at a,
weeks.
I don't have them on our docket for the 30th.
There's one Thursday a month, yeah.
I see. How about, what do I have on the first Thursday in August? Can I do it then or now?
We actually don't have them until August 20th.
I'm sorry, Heather, I didn't hear you.
We don't have them till August 20th in August.
Can do August 20th. Are you available?
Yeah, I am on.
I'm here that day, right?
Yes, you are, Judge.
I'll do August the 20th. August the 20th at what time, Heather?
Since it's a bench, do you want to do it at 11?
Sure. 11 a.m. on August the 20th, okay? So, sir, you'll go down the hall, we'll give you notice, and see you on August the 20th. Any questions? Anything else on that, Mr. Teal?
No, yeah, thanks.
You want those files there? And the other one, or you want to just go talking? Thank you. Okay. Lillian J. Star Trotter, 26B150733A and B. Good morning, counsel. How are you?
I'm doing well, Judge. Kenneth Campbell with me on behalf of looking at Your Honor, who is sitting to my right.
Yeah, I'm getting a little, can you get that device a little closer to you? Ma'am, tell me your name, please.
William Charles.
All right, just keep your voices up nice and loud if you would. I don't know, it's not coming through as strong as it usually does. So I have a plea agreement here. It says that the defendant is going to plead guilty to the added count, lesser included offense, I should say, of operating while visibly impaired, super drunk, or high BAC charge would be dismissed. Also, that the defendant is going to plead responsible on count 2 to an amended charge of distracted driving, and the prosecutor then is going to move to dismiss the open intox. Is that right?
That is a correct statement, Your Honor.
Ma'am, is that what you would like to do?
Yeah, sure.
If you plead guilty to operating while impaired, here are the possible penalties. $100 fines, 93 days jail, 360 hours community service, court costs, or all those, 4 points, license suspension or revocation in accordance with your record. Your vehicle could be, or might have to be immobilized depending upon your record. If you plead to distracted driving, that's a 0-point civil infraction. You understand that? It won't get reported. You understand that?
Yes, Judge.
And then I'm gonna dismiss the open intox and the super drunk. You understand that?
Yes, Judge.
I want you to understand that you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial. In a trial, you have the constitutional right to a trial by jury. You can subpoena your own witnesses. You can testify and remain silent. If you remain silent, the fact finder would be instructed that they could not hold that silence against you. Plead guilty, you're giving up all those rights. You're giving up the presumption of innocence. You're waiving the requirement that people prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, Judge.
Fully understand everything.
Yes, Judge.
You charge operating while visibly impaired, ma'am. How do you plead?
Guilty.
Were you operating a motor vehicle on West Jefferson or Campo in Brownstown, May 2nd of 26 at 2:30 in the morning?
Yes, Judge.
Prior to that, did you drink alcohol? And if so, what did you drink and how much? Nice and loud for me.
Yes, Judge, I have about 4 strikes.
Was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes, Judge.
In what way? Why were you pulled over by the police?
I hit a curb in my truck.
I'm sorry.
She stated she hit a curb, you're wrong.
You hit a curb with you when you were driving?
Correct, Judge.
Is that right, ma'am?
Yes, Judge.
Was there an accident then?
There was a car accident for parking.
What did you drive into then, ma'am?
No,
A what?
the radio garage, of course, I was near here, and West Jefferson.
All right, so you drove into the median and the police came to the scene?
Yes.
And were you administered a breathalyzer test at the police station, or was this a blood draw? Blood? Did you stipulate that the reading of .205 was an accurate reading for purposes of the plea? I'm sorry, I don't know why I'm having a hard time.
Yes, Judge.
Are you on probation or parole right now, Ms. Trotter?
No,
Anybody force you to plead guilty?
no,
In the charge of distracted driving, you plead responsible or not responsible?
responsible.
Plea is accepted to distracted. Plea is accepted. I find it to be inaccurate for the operating while impaired. I'm going to go ahead and dismiss the super drunk charge on motion of the prosecutor, as well as the open intoxicants on motion of the prosecutor. I'm going to refer you for a screening and assessment. They're only requesting 168. I give 2 1/4 on the blood draw, but if that's the extent of the bill, that's what they're going to get. We're going to have a screening and assessment. You're going to have to come up here, fill out a questionnaire, and be interviewed. Has she been going to AA, and did she show you proof of that?
I have seen the sheets, Judge. Yes, she's attending as required, under her bond conditions.
All right. I didn't realize the breathalyzer, I don't think, was this high. It's pretty high. I'll still keep it at once a week, but I need full compliance. Do you understand that?
Yes, Judge.
All right, so let's get a sentencing date for you, Mr. Camilleri. What do you have for me, Harvey?
July 15th at 8:30?
Is that good with you?
Yes.
Yes, Judge.
All right, we'll do July 15th at 8:30. I'm deferring the sentencing on the distracted. I'll send you at that time, but I do need you to come up to the court and meet with probation and fill out your questionnaire and be interviewed. Okay, ma'am?
Yes, sir.
All right. You seem very respectful. This is a lot of alcohol. We're going to make sure you don't have a drinking problem, okay? We'll take care of that, all right?
Yes, sir.
Good luck to you. Thanks, Mr. Camilleri. Have a good day.
Have a good weekend, Judge.
Thank you. Angela Ardith Rice Day, 26B83.